In terms of victim impact, there is a moving statement from A's parents, written by her mother. In the statement, she speaks of the profound cognitive and emotional difficulties their daughter faces. I quote from part of that statement. Our daughter's joyful spirit remains, but it is now wrapped in layers of frustration and silent pain. She watches her friends do what she cannot, and she carries it all inside with quiet strength. This tragedy did not just change our daughter's life, it broke something in us as a family. Every time we see her struggle, we ask ourselves why we came here and what we could have done differently. The guilt and helplessness are unbearable. For us, the trauma is relentless. We live with constant fear about the future, unsure how much more she will lose as she grows. We grieve for the dreams we once had for her, dreams of music, sport, and a carefree childhood, all replaced by therapy sessions, hospital appointments, and adaptations for survival. We are doing everything possible to show her that life is still full of possibilities, to make her believe that there is nothing she cannot do, and to make her smile. But the mental and emotional trauma we carry every day is heavy, a constant fear for her future, and a constant grief for the life she lost, and the life we imagined as a family. The statement also speaks of the financial impact on the family unit. They've had to relocate and make adaptations to their home at considerable cost to them. The statement refers to a figure of £40,000. You are now aged 33. As you told the jury, you've been involved in the commission of numerous criminal offences, many more than set out in your antecedents. The antecedents start back in 2008, when there is a conviction for battery. In 2011, at the Crown Court at Wood Green for a fray, a community order was made. Later in 2011, you were before the Magistrates' Court for using a vehicle whilst uninsured and possession of Class A and Class B drugs. Fines were imposed. In 2013, in the Crown Court at Wood Green for possession of cannabis, cocaine and dangerous driving, you were made the subject of a suspended sentence order. In 2015, for failing to comply with the terms of that suspended sentence, it was activated. In 2018, for using a vehicle whilst uninsured, a further fine and period of disqualification. Then in November 2018, for possessing an offensive weapon in public and possessing a bladed article, further custodial sentences were imposed. Whilst those are the convictions recorded, in your evidence you admitted involvement in numerous high-value robberies and drug dealing. You claimed to be a very successful robber and drug dealer, having never been caught by the police, as you chose to steal mostly from drug dealers and scam artists. Whilst I am not sentencing you for those matters, your admission to that offending is clearly relevant to sentence. I have seen and read a letter from the mother of two of your children. In her words, she says she knows you, and I quote, as a supportive, caring and responsible person. She describes you as a, and again I quote, a kind, protective and involved parent who always puts the children's needs first. She claims to be, and again I quote, aware of the matters before the court, and whilst I do not seek to excuse them, I believe they do not reflect the man I've known for so many years. He's demonstrated to me that he's committed to being a positive role model and continuing to provide stability, love and guidance for our children. The evidence in this trial is very much at odds with that impression. The account you gave to the jury of being a serial robber, someone who spent their days stealing from others, using or threatening to use violence when doing so, and a drug dealer. On your own account, someone deriving significant income from violent crime. Presumably, some of the financial support you provided to your family over the years has come from criminal activity. If the author of this letter is in fact aware of the matters before the court, it is odd to think that you are a role model for your own children. There are a number of other references that have been provided today. They include the mother of another of your children. Each of the writers speaks in similar glowing terms about you. As with the letter I have quoted, to me it is unclear that they know what you do to make your money, and if they did, whether they would still have the same thoughts about you. that whilst people can have many sides to them, and you may have appeared to others differently, the letters might have had some weight if written in a more open and rounded way. Turning to the sentencing guidelines, for attempted murder, in terms of culpability, the 3 counts of attempted murder all involve the use of a firearm. That is a characteristic suggesting very high culpability. You gave evidence about the £30,000 to £40,000 you expected to get from taking part in a robbery, and an offence committed for financial gain is another characteristic for very high culpability. In my judgment, there was significant planning in this attack. Planning or premeditation of murder are characteristics of high culpability. Balancing all the factors here, in my judgment, this is clearly very high culpability. On harm, serious harm was caused to 3 men. In my judgment, this is within category A as to culpability and level 2 as to harm. The guidelines suggest a starting point for sentence of 30 years imprisonment and a range of sentence of 25 to 35 years imprisonment. It must be noted that would be for a single offence and a single victim, and before any uplift for aggravating factors. For count 5, the guidelines for causing grievous bodily harm with intent need to be considered. On culpability, the offence would come within category A, as there was a significant degree of planning, the victim vulnerable due to age, the use of a highly dangerous weapon, you had a leading role as a planner and a spotter, and this was an act in revenge for previous incidents. On harm, this would be in the highest category 2 in light of the impact the injuries will have. On count 5 alone, a start point for the category of 10 years and a range of sentence of between 10 and 16 years. In line with my observations in terms of counts 1 to 3, this is again before consideration of any aggravating factors. In terms of aggravating factors applicable here, there are your previous convictions. Others were clearly put at risk as 6 shots were fired at close range into a public restaurant. There are the actions taken after the offence to conceal and destroy evidence. You are not the gunman. Your role is one that I need to have in mind. I am required to consider the issue of dangerousness. The test is this: is there a significant risk to members of the public of serious harm occasioned by the commission by you of further specified offences? In making that assessment, as well as taking into account all the information available about the nature and circumstances of the offences here, I may take into account any other information about you that is available. There is significant information about you. You told the jury on oath a pattern of committing as many as 5 robberies a month, robberies of not insignificant sums of money and drugs from others. On conviction, I considered whether a pre-sentence report should be ordered. The Sentencing Act 2020 makes provision for those aged 18 or over that the court must obtain and consider a pre-sentence report before forming the opinion on dangerousness, unless, in the circumstances of the case, it considers that it is unnecessary to do so. In my judgment, a report was unnecessary due to the extensive account you gave in the trial as to your background, family situation and lifestyle. And Mr. Smith did not seek to persuade me that such a report was required, notwithstanding that a discretionary life sentence may apply. In the light of the facts of this case, a targeted shooting of rival gang members, and all that I know about you, in my judgment, the dangerousness test is met, and by some distance. Having come to that view, I have to consider the provisions of Section 285 of the Sentencing Act 2020, and whether the seriousness of the offence, or the offence and one or more of the offences associated with it, is such as to justify the imposition of a sentence of imprisonment for life. If so, then I must impose a sentence of imprisonment for life. I have very much in mind what was said by Lord Thomas in the case of Berinskas, that a life sentence remains a sentence of last resort. In my judgment, the seriousness of the offences here is such that such a sentence is justified and should be imposed. The issue for me is the appropriate minimum term to be imposed. When it comes to that minimum term, I make plain that I am not ordering that you are released at the end of it. Whether you will be released or not at that stage will be a matter for the parole board to consider. Only when the minimum term has been served can the parole board decide whether it is safe to release you or not. If the parole board does release you, then you will remain on licence and liable to recall for the rest of your life. I note in passing that had the victims here died and you'd been convicted of murder, it's very likely that this case would have been met by whole life orders being made. Would you stand, please? In my judgment, taking into account the aggravating and mitigating factors I have identified, and reflecting the overall offending here, 3 counts of attempted murder and 1 count of wounding with intent, the appropriate determinate term would have been one of 51 years imprisonment. Making 2/3 of that notional determinate sentence as the appropriate figure to determine the minimum term, there will be a life sentence with a minimum term of 34 years. The days on remand, which I'm told number 398, will count towards that sentence, and so the minimum term will be one of 34 years less the 398 days. On each of counts 1, 2, 3 and 5, there will be concurrent sentences of life imprisonment with a minimum term of 34 years less the 398 days. That equates to 32 years and 332 days. I order the forfeiture of all the drugs and paraphernalia seized. A schedule has been compiled identifying those items. I have postponed determination of any financial orders so that consideration can be given as to how best to deal with any cash or other assets found. For example, some £7,000 was found in the course of the searches. The matter will be listed in due course for any financial orders to be considered. As and when it is listed, I will also deal with the statutory surcharge. You may go down.